Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. In this presentation, we will look into the sanctions as a risk or consideration in structuring M&A transactions. And more specifically, we will look into the following points. We will discuss, first of all, what may be the potential elements of sanctions risks, which need to be considered in the context of an M&A transaction. And then we would look into most relevant considerations, which, if identified, need to be factored into the general transaction flow, costs, timing, and the risk of closing, namely the application of blocking sanctions to the parties to the transaction, namely the seller, the purchaser, any guarantor, if there is a guarantor of any party, the target itself, being either the company which is sold or purchased or the asset, other relevant considerations which may arise in the context of the M&A transactions, and we will conclude by the sectoral sanctions, which are less relevant than the blocking sanctions, but still may affect the structuring of a transaction. The starting point to note is that in the modern world, sanctions is a risk which requires special attention and clearance in every cross-border M&A transaction. If 10 or 15 years ago, this would be a rare occasion when the sanctions will apply and be relevant, in today's world, when the use of tariffs by the United States is almost the most important part of the US policy, certainly affecting international trade flows, when major economies like Russia are subject to comprehensive blocking and sectoral sanctions, sanctions risk is an element of structuring which has to be considered and cleared in every transaction in the same way as litigation risk, environmental risk, regulatory risk, tax claim risks, and various other risks which have been habitually considered. So sanctions is a new development, but is certainly on the table by now for a substantial period of time. So how may a party approach the risk analysis and the relevance of sanctions for a particular transaction? Well, the starting point to consider are the sanctions regimes which may be relevant. And that's not an easy exercise because the regimes may apply in a way which may not be expected at the very beginning. And accordingly, it's important to analyze every regime which may apply first to the parties of the transaction, which may not be located in the same country, and so at least the jurisdictions of those countries would be relevant. The target, which may be located in third-party jurisdictions. The locations of any important service providers involved in the closing of the transaction. For example, if the purchaser finances the purchase price in part with the loan proceeds, then the location of the bank would be another important jurisdiction to consider. It's important to note that sanctions would typically affect the persons themselves as well as the shareholders in such persons, as well as their directors and the employees, which are subject to personal restrictions. And accordingly, we need to add another layer of the jurisdictions which may be brought into picture because of the shareholders of various parties, or because of the directors or other persons involved into the closing of the transactions. And what is less common to consider, but is more and more relevant, is certainly the overall market risk, which is now closely connected to sanctions as well and has a sanctions element due to the ever-increasing use of tariffs, which is a type of sectoral sanction restricting trade. Another important consideration is that some regimes are extraterritorial in nature and may be relevant even if none of the elements, which we discussed above, is located or is connected with such jurisdiction. So even if we have a pure EU-based transaction with all parties, the target, the banks, the payments, the service providers, the markets being located in even in one EU country, but when any of the persons to such transaction is subject to the US blocking sanction, there is a extraterritorial risk connected with such sanctions, namely that the person is transacting with a blocked person in the absence of the relevant license from the US authorities carries itself the risk of being subject to the blocking sanctions. Another important consideration, which we briefly discussed, is the overall market risk, which is currently in part is connected to sanctions, namely the use of tariffs. And so once that preliminary analysis is made, and once those considerations are carefully considered and the relevant regimes which may directly and indirectly affect the transactions are identified, it's important to understand the scope of any relevant restriction, whether any exemptions would be available to complete the transaction under the current laws, or whether a separate license will be required, what will be the timing, the legal cost, and the closing risks associated with such license. We will now consider the main elements of sanctions which appear in the context of M&A transactions and how they may or may not be addressed. The first and the most important factor is certainly one of the parties, namely a purchaser, a seller, or a guarantor of any of the parties, be subject to the blocking sanctions. But this is the most evident and the most complex situation, because in essence, it's prohibited to provide any financial resources, any funds, anything of value to a person which is subject to blocked sanctions. That's almost universal rule in any jurisdiction. And from that perspective, the M&A transaction, which implies the exchange of value with a blocked person, will be prohibited. If that is your situation, then the only potential way to complete the transaction would be to seek the individual licenses from the relevant national competent authorities involved. And we've already discussed the scope of national competent authorities which may be involved in a typical M&A transaction. And it's important to note that as a general rule, in each of those jurisdictions, a separate license will be required because there is no passporting of licenses, even within the European Union. Certainly not so within the jurisdictions outside of the European Union, like the US or UK, for example, or Switzerland, being the most relevant jurisdictions. And from that perspective, this certainly creates, at minimum, delay and legal cost, and at maximum, substantially increases the risks of closing, because none of those competent authorities is obliged to grant a license, to grant license to various conditions, which will not be acceptable for the parties. And so that certainly involves a substantial risk, and completing an M&A transaction with a party subject to block sanctions is presumably one of the most complex transactions in this area one can think of. Interestingly, block sanctions may be relevant not only if the parties to the contract are subject to them, but also if the target is subject to block sanctions. Just to clarify, we here discuss a situation when the seller and purchaser is not blocked, and so under normal circumstances, they can transact with each other without any type of restrictions. But the transaction itself relates to a target, being either shares in a company or, for example, an asset, a vessel, by example, which is subject to blocking sanctions. One may assume that as the transaction itself does not relate to the transfer of anything of value to the target, so the exchange of consideration is in between the parties, none of which is sanctioned, this should not be a concern. At least in the United States, that is not the case. To the extent the target, meaning the company with respect to which the transaction occurs, is a blocked person, the transfer of shares of debt securities in this target is deemed to affect this target and is deemed to constitute dealing in the assets of the target itself, and as a result of which subject to restrictions which apply to the target, which in practical terms means that the completion of the M&A transaction and the conduct of negotiation with respect to the target, we'll talk about these in a minute, would require licenses from the US regulatory authorities. Typically, the US regulator will issue so-called divestment licenses, meaning at the time of designating a target, the US regulator will open a short window, allowing the US investors, and by analogy, all foreign investors, to sell their participation in the target without requesting a separate individual license. But in practical terms, those general licenses are not universal, will typically apply only to publicly traded companies with a substantial number of investors rather than to private companies, for example, will be short in time, we talk about 3 to 4 months, sometimes 1 month, which is a period quite short to complete any meaningful divestment, as well as subject to other conditions. So the licenses are there, but their purpose is quite narrow and the timing is quite short. The EU's general approach is that as the transaction is between non-sanctioned entities, the fact that the target is subject to sanctions does not automatically result in the provision of anything of value to the target, and accordingly will not require separate authorization. That's an important distinction. Having said that, it appears that from the practical perspective, this rule can apply only to the extent the EU owner divests of a blocked target, because the acquisition transactions will subsequently require various licenses, for example, to obtain dividends from the target, which is a blocked entity, and accordingly the distributions will be generally blocked, exercising voting rights and other similar type of restrictions which result from the ownership of participatory interests in a blocked entity. And given that the grant of those authorizations is subject to the discretion of national competent authorities, there is certainly a substantial risk that they will refuse to do so if the acquisition occurred following the imposition of blocking sanctions with respect to the target. So although the regime is different, in practical terms, both regimes in general terms allow the divestment of participation and are difficult to accommodate any kind of acquisition transactions. Other relevant points which arise in the context of blocking sanctions and M&A transactions relates to a specific point of US law where the blocking sanctions in their nature are so wide that they cover even the preliminary discussion with a blocked entity with respect to an M&A transaction. So typically the M&A transaction will be structured in a way that the negotiation occurs, the contract is signed, and any kind of regulatory approvals, including sanctions, are condition precedent to closing, meaning the transfer of ownership to shares and the payment of the purchase price, which in the context of any regulatory approvals being required will occur after the execution of the contract. So there will be 2 dates in a transaction, so-called signing date, when the contract is signed, And then there will be a period of time agreed between the parties when the condition precedent, including all regulatory approvals, need to be satisfied. And if they're satisfied, then the closing will occur and the parties will exchange shares against the consideration agreed for the shares. In the US, the scope of the blocking sanctions is so wide that it would not be possible to structure an M&A transaction this way, as a separate approval will need to be obtained to have preliminary discussion on the terms of the transaction, to make the due diligence, and to sign such a conditional agreement. So it's advisable to have a two-stage approach to the extent US sanctions apply. The first one is to get the authorization for these preliminary discussions. And the second one is to get the authorization for the completion of transaction itself, or if the relevant regulatory authorities are agreeable, to get one authorization as early as the first step in a transaction occurs, namely the negotiation start, and such authorizations covering both the pre-closing process and the closing itself. In the EU, the restrictions are different. Blocking sanctions require that nothing of value is provided to a blocked person, and under a conditional contract, when the completion is subject to a regulatory approval, nothing of value is provided before completion. So from that perspective, the authorization is not required to have the initial discussions, to do the due diligence, and to sign a conditional agreement, which is certainly a more practical approach from the cost perspective. Another important element, which is quite often overlooked up until the very end of the transaction process, causing lots of anxiety to all parties, is the effect which the blocking sanctions may have on third-party intermediaries involved in the transaction in one way or another. That somehow is coming up usually at a very late stage because the parties are largely focused on the identity of their counterparty as well as the commercial terms of transaction. And up until the late days in the transaction, pay little attention, for example, to where the proceeds of the purchase price will be paid, what kind of correspondent banks will be involved in the payment of the purchase price, what will be the depositories involved in the transfer of shares. Are there banks which will provide financing for the purchase price? Are there banks which need to be refinanced as a part of the transaction closing? All these elements, to the extent sanction affects any of those parties, have to be considered early on in the transaction process because they may all disrupt or substantially delay closing. Final point to consider is the relevance of sectoral sanctions. Sectoral sanctions are the sanctions which, unlike the blocking sanctions, which prohibit all type of interaction with a blocked person, to generalize, sectoral sanctions, as a general rule, do not prohibit the interaction with a person subject to them, except if that interaction relates to specific transactions which sectoral sanctions purport to restrict. So the overall rule in the blocking sanctions is that everything is prohibited unless expressly allowed. The general rule in the sectoral sanctions is the opposite. Everything is allowed unless expressly prohibited. Typically, sectoral sanctions will be imposed to regulate trade. So, for example, tariffs or additional restrictions on the supply of sensitive items will be the most common example, or access to financial markets. So they will restrict borrowing or, for example, raising capital by way of equity in the relevant markets. And from that perspective, they are rarely directly made to somehow restrict the M&A transactions. Nevertheless, this can happen indirectly. And here I summarize one of those examples which may be relevant. The general tariff risks we've already discussed. If the target has substantial customers or substantial part of its business overseas, and the relevant jurisdiction, for example, US, is keen to impose tariffs, this has to be factored into the overall risks. There may be restrictions on the payment of the purchase price. Here, by way of example, I would mention European Union against Russia, which generally restrict payments by way of prohibiting to accept deposits from Russian persons exceeding 100,000 euros equivalent, unless those payments are made in connection with specific purposes, and those purposes on strict reading will not include M&A transactions. The financing restrictions which we mentioned may apply to the terms of how the purchase price is to be paid. For example, deferred or advanced payment of the purchase price may be considered to be the financing of the relevant side to the transaction. And from that perspective, to the extent this occurs and the relevant party is subject to, for example, the restriction on the financing or any other similar restriction, these terms will not be acceptable. And finally, there are sanctions which are in their scope, although sectoral from the literal perspective, in their practical scope, quite closely approach to blocking sanctions, the so-called transaction ban sanctions, which are now quite common in the European Union. So they will not designate a person as a blocked person, but they will prohibit all types of transactions with the relevant person, except for those specifically mentioned in the regulation. And again, those categories of transactions will not allow typically any kind of M&A transactions. I trust that you found this presentation useful. Thank you very much for watching, and I hope to see you during my next presentations.